and the Uber driver that may not be so helpful to the prosecution's case.
Absolutely. I was wondering last week, as the prosecution was calling their witnesses for this preliminary hearing, are we going to hear from that Uber driver at any point? You know, we've heard about that piece of the investigation for months now, that an Uber picked up Celeste in Lake Elsinore, where her family lives, and then dropped her off at David's home, just about 80 miles away in the Hollywood Hills. We haven't heard from this Uber driver yet. Well, that came up today in court. Apparently, LAPD did interview that Uber driver, and he denies having any recollection of that trip. He cannot definitively confirm that he dropped her off at that time, just after 10 p.m.
3 turning points changed this case in a single day inside a Los Angeles courtroom. First, an Uber driver who was supposed to place a 14-year-old girl at a house in the Hollywood Hills told police he doesn't remember the trip at all. Second, text messages that prosecutors say prove a motive for murder also revealed something else, something the defense used in their closing argument. Third, a security system that could have shown, once and for all, who entered that house that night had already erased itself months before anyone thought to look. This is the preliminary hearing of David Anthony Burke, the man accused of killing Celeste Rivas Hernandez. What follows is documented, on the record, verified in open court. Not speculation, not theory. Here's what we actually know, and here's where the record itself still leaves questions open. Let's start with the Uber driver, because this is the detail most coverage has moved past too quickly.
That night, and he does not remember picking her up or driving her there. That is absolutely a hole in what the prosecution has been alleging for months now.
And no surveillance footage of her showing up or him being at the house, which, if I'm reading it correctly, again, seems to be problematic, which I know I'm jumping around a little bit because I do want to get a little bit.
For months, the timeline of April 23, 2025 rested on one assumption, that a driver picked up Celeste in Lake Elsinore and dropped her, roughly 80 miles away, at a home in the Hollywood Hills, just after 10 p.m. That assumption came from phone records and from text messages, where Celeste tells David she's arrived. But here's the complication. When LAPD detectives finally located and interviewed that driver, he said he has no recollection of the trip. He could not confirm definitively that he dropped her off at that time, at that address. He does not remember picking her up. He does not remember driving her there at all. Worth sitting with for a moment. This isn't a driver denying the trip happened. It's simply a memory that isn't there. And for a case that leans heavily on documented movement, verified by data, this is one thread that doesn't tie itself off cleanly. This is where myth tends to outpace fact. Online, this detail has already been stretched into claims that the trip never happened at all, that the timeline is fabricated. That is not what the record shows. The record shows phone data and Tesla data, both placing David's vehicle, moving away from that home, later that night. What's missing is simply independent human confirmation of the pickup and drop-off. A gap, not a contradiction. Now, the second turning point. The text messages. Prosecutors and defense attorneys presented the exact same conversation between David and Celeste from the 2 nights before she died. Same digital evidence. Very different framing.
This was so fascinating to me, Jesse, because opposing counsel here, the prosecution and the defense, they're presenting the exact same digital evidence here. They're presenting this same text message conversation between David and Celeste. And based on what these different attorneys are essentially cherry picking from these conversations, we are getting a very different view of what happened between the two of them and what was said the night before Celeste was.
The prosecution used select messages to establish basic facts, location, timing, coordination of the Uber pickup. Simple, documented, chronological. The defense, on cross-examination, asked to see more.
Now, then on cross-examination, Blair Burke was questioning LAPD Detective Corey Farrell, and she asked to show the court additional messages from that same conversation. That's where we started to get a little bit more color about the argument that has been referenced previously in the prosecution's charging documents. This is where we actually saw text messages from Celeste to David threatening him.
And that's when messages surfaced that had not been previously public. Messages where Celeste tells David she's going to ruin his career. That she'll tell his mother damaging information. That she has contact information for his business associates. Here's the mid-script correction, the detail that resets everything you thought you understood about this exchange. Many assumed, based on the original charging documents, that Celeste's threats were specifically about exposing a sexual relationship. The record does not support that as clearly as assumed. According to testimony, Celeste never explicitly stated in these messages that she would disclose anything criminal. She alluded to material she had. She threatened exposure broadly. But the specific words, the ones many expected to find, are not there, verified in the text record read aloud in court.
There was a lot, Jesse, that was said in these text messages, and there was a lot that really was not spelled out. Keep in mind, too, a lot of this was typed out in Gen Z shorthand, in text message format, and it's little blips of back and forth. But let me tell you what these messages did not explicitly state. And this is what the defense brought up during their closing statements just now. Celeste did not, at any point during this back and forth, based on what we've seen in the courtroom today, explicitly threaten to disclose anything criminal about David. She did not spell that out. But
why this matters is not small. Those same ambiguous messages are the foundation for two of the special circumstances that make this a death penalty eligible case: murder for financial gain and murder of a witness.
Absolutely. I mean, that is child sexual abuse material. She references that. She talks about reaching out not only to David's mother, but people on his management team. So that speaks to two of the special circumstances in this case that make the first-degree murder charge eligible for the death penalty here in California. That's, of course, murder for financial gain. There was some back and forth just now about whether preventing financial loss constitutes financial gain. The prosecution is alleging that it does, in fact, count. And there are several cases here in California that set a legal precedent for that. This also speaks to another special circumstance under that first-degree murder charge.
The prosecution argues preventing financial loss counts as financial gain under California precedent. The defense argues the threats were never concrete enough to establish those circumstances at all. Here is a genuine open question, one the documented record does not resolve. If a threat is implied, but never explicitly named, does it meet the legal standard for lying in wait or for witness elimination? Legal analysts are divided. We'd like to know how you read it in the comments.
Here's where there might be an issue, though. Lying in wait. it seems to me, based on the text message conversations we were just parsing through in the courtroom, that Celeste was actually the one who demanded she and David have this meeting on the evening of April 23rd. She was the one who pushed him to have an in-person conversation. They were fighting about whether he was dating somebody else. She became very upset after seeing social media posts featuring the two of them. And it sounds like that was what triggered this argument. So she demands to see him. He tells her no. He's getting ready for a trip to Singapore. He says his parents are there visiting. He doesn't have time. She demands to see him. And finally, he gives in. So we previously did not know that about this argument. We thought that he arranged it.
Well, he did get her the Uber.
Third, and this is the angle most coverage has underexplored, the surveillance footage that doesn't exist.
To your point too, Jesse, about that surveillance footage or lack thereof, absolutely. I mean, there is irrefutable hard evidence for so many other things, right? Phone records, Tesla records, text messages that spell out what people were saying and doing at specific times. There is no surveillance footage actually showing David or Celeste going into or coming out of the Doheny Place home where he was staying at the time. The LAPD detective, Corey Farrell, the final witness for the prosecution during this preliminary hearing, he spoke to that today. And he laid out what I thought was a very reasonable explanation. He says by the time they tried to access that security system to search for that video, it had been so long, it had been months. And
There is no video showing David or Celeste entering or leaving the home that night. According to the detective's testimony, by the time investigators tried to pull footage from the home security system, months had passed. The system had already overwritten itself. No one knows, on the record, whether the cameras were simply left running or whether they'd been disabled deliberately. That distinction remains undocumented and unresolved.
the system simply overwrote itself. It wasn't stored there anymore. Now, we don't know if somebody may have gone back and deleted that. We don't know if the cameras may have been turned off during that time. All we know is there is no video. So what the prosecution has been alleging this whole time, that David stood by and watched the victim bleed out, well, there's no video documenting that. So we have to wonder, Jesse, if they're going to call another witness to the stand during the trial who can say that they saw that happen.
Well, I think what I was hearing today from the prosecution is they're assuming that happened because the argument would be there was no outgoing call.
This absence cuts both ways. The prosecution's theory that David stood by while Celeste bled out has no video to confirm it. But the medical examiner's own testimony complicates the timeline further. He testified the injuries could have caused death anywhere from minutes to an hour. Advanced decomposition made a precise cause and timeline impossible to pin down with certainty. He could not say which of two wounds occurred first. This is a documented limitation of the evidence itself, not a resolved fact in either direction.
To emergency services. Although it seems to be complicated a little bit because the defense was saying your medical examiner, right? The medical examiner said that we don't know how long it took for Celeste to succumb to her injuries, right? So this idea that you claim our client was watching her bleed out, it seems that it's complicated by the ME's testimony, right?
That's right. I mean, he testified the other day, either one of those two penetrating wounds that they attributed her death to, either one could kill somebody in, quote, minutes to an hour. That is a pretty wide window of time. And he simply can't say, and that's because of the advanced state of decomposition. She may have been dead for weeks to months before her body was found. We saw in very graphic imagery exactly what her body looked like. when the pieces were found in body bags inside that vehicle. So he can't say which penetrating wound happened first. It took them about 3 months just to finalize their autopsy findings and confirm her cause of death.
One more name that surfaced today and deserves attention, an LA-based social media figure named Asia Collins.
I have to tell you, I was reading your notes. An interesting name popped up. Somebody that I was wondering if they were going to testify at this preliminary hearing. Somebody that we knew was a purported associate or friend of David. Somebody who created some social media video in anticipation of this case. And that is Asia Collins. We never really understood what her connection or role was to this. We sure did get a lot more information today about Asia Collins, didn't we?
We did, Jesse. Turns out Asia Collins, who is an LA-based influencer, social media model, she's got a presence and a platform online. Turns out
testimony connected her to the argument that preceded Celeste's death, a rumored friendship that Celeste reportedly resented. Collins has publicly stated, on the record, that she never dated David and that she wants justice for Celeste.
Was her association with David and their rumored friendship or perhaps early stages of dating that made Celeste incredibly upset. And that is what Celeste cites as the source of her anger when she is threatening David and telling him over text the night before he sent the Uber to pick her up and deliver her to his home. She tells him over text that she's going to, quote, mutilate his. She tells him that she doesn't want to see one more instance of David being tagged in posts with Asia Collins. Asia did come out on the record and state publicly, after the charges were filed against David, that she never dated him. She also came out and says she wants justice for Celeste. Now, we don't.
Her exact role going forward remains undetermined. By the end of the day, Judge Charlane Omeo ruled there was sufficient cause to move this case to trial on all 3 felony counts: murder, mutilation of human remains, and continuous sexual abuse of a minor. That's the legal standard. At this stage, probable cause, not proof beyond a reasonable doubt. The defense presented arguments. Arguments are not evidence.
The defense made many arguments. The defense did not present any evidence. And by the way, the defense doesn't have to do anything in a criminal case. At all points in time, a defendant is presumed innocent until and unless proven guilty. And today it was by probable cause. And at a trial, it will be beyond a reasonable doubt. We will have to convince 12 jurors unanimously to find every element of the crime in order to actually get a conviction. So the defense has made many arguments. Again,
that distinction was repeated by the DA's office more than once, and it's worth remembering. Arraignment is scheduled for August 31st. Bail has been denied.
Tuesday morning.
Julia Dang, thank you so much for coming on. I really, really appreciate it. So after I finished up with Julia, this is what came out of court. The judge found that there is sufficient cause to believe the defendant is guilty and to move this trial on all 3 counts, talking about how such a low standard it is. The judge reminded this is an exceedingly low standard, sufficient cause to hold someone to answer, again, probable cause. Apparently, David was staring straight ahead at the judge with his arms folded in front of him as she was reading this case, the law notes, court decisions. So yes, the judge found that there's sufficient probable cause. This is going to move forward. And it appears that an arraignment on these charges is going to be held on Monday, August 31st at 8:30 a.m. Bail is.
What remains unresolved is not whether this case moves forward. It does. What remains unresolved is which version of that night a jury will eventually believe, the one built on data and testimony, or the one the defense is still constructing, piece by piece. The documented record doesn't end here. It continues at trial. If you've been following this case since the beginning, you already know How much has changed since September? Tell us in the comments which of these three gaps, the driver, the messages, or the missing footage, you think matters most heading into trial. And follow for our next deep dive when the arraignment moves forward.